Tonight, Totally, we talk about IP and how it can protect innovation and invention. Without further ado, let me pass the time to Totally. Totally.
Okay. Thank you, Taurus, and also thank Lawrence for inviting me to speak in this very prestigious academy. And Lawrence gave me the topic, and I think it's quite broad. And I know IP is very technical and also cover many areas. I don't really know how to talk about this topic in 40 minutes, but I will try to introduce you to some basic concept of IP law, and then I will discuss the relationship between IP and innovation, and then I will go through some of the interesting cases about technology and copyright, and also the technologies and patents. And then lastly, if time allows, I will probably use some time to talk about how to exploit the IP rights and technology transfer. Okay, I'm going to share my slides here. Okay. Yeah. Okay, so the topic is IP and its protection for technology, innovation, and invention. So my focus today will be on the innovation and the invention. But before getting to innovation inventions, and I'd like to have a brief introduction to the basics of IP law, in case that some of you have no background on IP. First of all, for the definition of IPR, the term of intellectual property was first used by the scientist and the philosopher Joseph Kohler and Edmund Picard in 1845. And then it was officially adopted in some international IP convention in 1950s. And basically, according to World Intellectual Property Organization's definition, IP concerns product of mind, covering inventions, literary and artistic work, any symbols, names, and images, the designs used in commerce. And sorry, I need to see. Okay, and IPR are the rights given to people over the creation of their mind, and the creators can be given the right to prevent others from using their inventions, design, or other creation. I highlighted the product of mind and the creation of the mind. So you can see the IP is about creativity from people's mind. Also, I also highlighted the use in commerce. The user in commerce means that the IP also have some commercial values. It's not a purely, ideas or enjoyment or luxury. It's also have a commercial value. And also I highlighted the right to prevent others, which means that IP right is actually negative right, which means that the right is mainly used to prevent other people from using the inventions or your copyright. It's not really an entitlement. It's not the right to allow you to do something. Of course, if you have the right, you can exploit. But the main purpose of the IPR is to prevent other people. So it's a negative right. And also IP right was defined as the idea, invention, technology, artwork, music, and the literature that are tangible when it first created, but become valuable in tangible form as product. So like the computer, right? When you design the computer, you have an idea, you have the invention, but then it's eventually reduced to the computer, the hardware. And they But when you sell your computer, you don't really necessarily transfer your patent rights in your idea. So the patent rights or IP rights is intangible. It's you can really not really you can see or you can touch, unlike the real property. So the characteristic of IPR include the intangibility that I already mentioned, because it's all concerned about the creation, like in literary and artistic creation, or the sign or names, and also invention or know-hows. So all of those are intangible, unlike the real property. And then all of those rights relate to the creativity, because for copyright, the works is required to be original. And for the trademark, the name and the signs require to be distinctive. And then for the inventions, the invention need to be new and inventive and useful. So it's all about the creativity and the innovation. And IP is also monopolistic because it grants exclusive rights to the people who create the works. And the monopolistic right is given to the authors in copyright law for life plus 50 years, or in some other countries, the life plus 70 years. And for patents, it's normally 20 years from the date of filing. And then for trademark, it's about, normally it's 10 years, but it's renewable every 10 years. And this monopoly rights, it's also limited by some other measures like compulsory license and fair use and fair dealing, or the antitrust regime. And lastly, the IPR is also territorial, which means that the right can only be exercised with a national border. So there's no such IPR at the international IPR. So if you want to protect your IPR in country A, then you need to go to country A to file the patent or register your copyright or register your trademark. And if you want to go to country B, then you basically have to file the patent in specific country to get the protection. You cannot get like an international patent to cover every country. And the categories normally divided into two big categories. One is the copyright for literary and artistic work, and another category is industrial property, covering patents, industrial designs, utility models, the trade secret, trademark, geographic indication, and unfair competition. And then sometimes when you're learning the IP law, you also see the words like a sui generis regime, a sui generis system. Those are the area that is related to IPR, but sometimes the national government thinks that they should be separately regulated because their special need or the uniqueness or the importance to the country. So some countries have a separate regulations for plant variety or database or topographic of semiconductor chips. But sometimes in some countries, they also use IP law to cover this area. So sometimes there's an overlapping between IP protection and the sui generis regime. And in order to get your IPR to be protected for copyright, basically it's automatic protection without any formality under the international treaty. basically you don't need to do anything to get protection. However, in practice, it is always recommended to put that notice, like trademark, copyright notice, and also to register if the jurisdiction have a copyright registration system, and also deposit. And some countries require that you also deposit your copy of your work. But in Hong Kong, there's no registration system. So in Hong Kong, basically, if you put the notice of the copyright, then that would be sufficient. For patent, you have to file the patent application, and you have to file as soon as possible, usually by US provisional application and also PCT. But before you file the application, you need to be aware. You should not disclose your invention to anyone before you file the application. I will talk about that a little bit later more. And for trade secret, there's also no need to register or apply the, basically you need to adopt reasonable measures to preserve the secrets, particularly before you file the patent application. So trade secret, the longest protected trade secret is the Coca-Cola recipes, but that require a lot of work to preserve that secret recipe. So nowadays, I think a trade secret, particularly for anything involved the internet or collaborative works, trade secrets are very difficult to protect, to preserve. And trademark, you need to register. And as I said, it's territorial. So you need to register in countries where you plan to market or you want to prevent others from marketing your product. And trademark include also service mark and sometimes trade dress, trade name, or the collective marks, all sort of marks. Okay, and now I'll get into the relationship between IP and innovation. And look at this, all of those pictures, and you see all of this have a patent protection for the iPhones, the computers, and the cameras, or cars, or plane. Yeah, it's easy to understand. They are, you should get their conventional invention, and all have a patent protection. But for the animals, like Dolly the sheep, that's a cloned sheep, and also the mouse, this genetic modified mouse, and also drugs and the trees, like plants, and even the genes, the DNA, also Michael Jackson's dance move. And I don't know if I have time to play that. I may skip this. Michael Jackson, the anti-gravity dance move. And he actually got the patent over the shoes he designed. So when people wear that shoes, they can dance, they bend to the over 45 degree, and that's called the anti-gravity move, dance move. That was also patented. Okay, so the patent, a lot of things can be patented. And so you can see there's a close relationship between IP, particularly patents, and the innovation. And of course, definitely IP have the positive roles in innovation. It can provide the incentive to innovation. And then there's a lot of theoretical justification about why the IPR is necessary. I don't have time to go over all of those, like natural rights series and also personality series, utilitarian series, all of those series. I would just focus on this economic analysis of IPR. And according to a lot of the scholars, and IP really provide the incentive to like inventors to have to invent, because they have the monopoly, and they can maybe sell their product with higher price, and so they can have a decent economic income. So they have a more incentive to innovate. And for investors, there's also incentive for them, because if the product or the invention is protected by the patent, then they can invest the money, and then they can sell the product with higher price, and they can have a decent economic return, and then they can also use the money to have a further investment in R&D, and with the firm as well, they can reinvest in R&D, use the profit gained from the IPR, and they can also use some strategies, and they can also benefit from like a market stealing, licensing, or signaling in the market. And if you have the patent, then you may take the large portion of the market, and you can also profit from licensing your invention. You can also send the signal to the consumer that your product is it's innovative, and it also have a higher quality or something like that. And patent or other IPRs can also be used as the market strategies, like using in the patent pools or patent trolls and patent secret to prevent the competitors from competition, and have a more control of the innovation and the market, and prevent other people from invent around or reverse engineering your product. So there's a lot of advantages and the benefits. And another benefit of the IPR or the patent is disclosure, because when you file the patent, you also have to disclose your invention, to publish your invention to the public. So the other people can learn the new technologies through learning from your published invention. And so basically, it's a bargain between inventor and the society. You get 20 years of monopoly, and then society gets access to your new invention. And so according to Harvard professor Adam Jeffs, and the creativity is very important, but it's really useful when it's first converted into commercially useful new product or process. And also this stage of converting is very costly and uncertain. Therefore, IPR is there to provide measures of predictability and protection to his expensive process of product and the process. And so IPR basically lies at the heart of technological progress, and also it's a primary engine of economic growth. That's very important. The IPRs, particularly patents, play the role from the beginning to the end of the whole commercialization, from the beginning of a perception of the innovation idea, and you need to start to think about whether you want to use trade secret to protect all the patent, and then when you're after that, you need to think about when you start to do the R&D, you need to think about applying for the patent. You need to do the search and the research on the patent documents and the filing the patent and applications. And then, you need, after filing the patent, you start to do the further R&D that require a lot of the investment, particularly like financial investment. And then during this period of time, IP played a vital role, and some scholars call it the lifeline while passing through the valley of death of innovation. During this period of time, the IPRs always play very important role when you use external technology and resources, and when you trying to find the financiers, or when you start to sell and license your product, or when you form the joint ventures. So all of those processes will involve the IPRs. And one of the examples is the person who invented the Xerox machine, and when his name is suddenly it's slipped out of my mind. It's Chester Carlton, I think, and he invented the Xerox machine in the beginning, but he couldn't find the investors for a very long time. And in the beginning, he filed the patent for that, and then in the beginning, a lot of companies rejected. Even IBM rejected his proposal, and then eventually he found another company after many years, and then eventually he succeeded. And the last stage of marketing of innovation involves trademarks and industrial design. Of course, you need to promote your product in the market, and then trademark and industrial design is very important. And the IPR can also become impediment to innovation because it's very costly to administer, right? For the national government to preserve the patent office, and it's very costly, and for the inventors, it's very costly to apply for the patent or maintain the patents. And also, IP may impede the cumulative innovation. Those innovation depend on the further previous innovation, because if you have an IP protection, then other people, the improver will have a difficult time to do their research. And also the consumer suffered the high price. Look at this diagram here. Now, if there's no IP or patent, then consumer will pay a lot less. But if there is a patent and the price is higher, and then the consumer will pay more. And then there's a section called dead weight lost, the C, section C. And that is basically it's totally wasted. It's not very sufficient, effective or sufficient. So the IP have those kind of side effect to innovation. So whether patent is good or it should be broad and narrow, or should be exist at all, and which innovator should be granted the patent, the innovator, original innovator or improver, or downstream or upstream developers, and which is right. And according to Professor Bach and Limoney, everyone is right, because it really depends on how do you look at the role of IPR. Okay, I move on to some cases. I don't know if I have time to cover all of the cases, and I have chosen several important cases in copyright area and also in patent area to demonstrate the importance of IPR to the innovation. The first case I chose was William versus United States about the library copying of a journal article for research use. Then the publisher, the medical journal publisher, William and Wilkins, alleged that the copyright infringement and sued the NIH library and also another national library for copyright infringement. That was only that happened in 1975 when the laser printer started, and then court look at whether between the injury to the copyright owner and injury to science research, which one is more serious, and then the court decided, if we stopped this photocopying of the research, the journal articles, then that will have a serious injury to science and research. So they held that photocopying of the journal article is a fair use, so it's not an infringement. They said that since the record here show that the medical science will be seriously hurt if the photocopying practice by the involved agencies is stopped, and conversely, the record failed to show that the plaintiff or other such publisher will be substantially injured. So the photocopying is allowed, and the photocopying machine can continue to be used in the library. So in a sense, that have encouraged the innovation of photocopying. And then another invention is about videotaping. Videotaping and the Sony company have produced the device to a so-called Betamax device to make a videotaping of the TV program and used for later viewing. And then Universal City Studio, that is the movie studios, and together with other movie studios, and they sued Sony for copyright infringement because they said that in the device of Betamax device encouraged the user, the people to videotaping the TV programs. And then eventually the court decided that using the phototape, the home take videotaping to do the home taping was time shifting, and it's a fair use. And they also provided the Sony safe harbor, saying that the manufacturers of those home video recording device will not be liable for infringement because their use for the substantial non-infringing purpose. Okay, so if it's any devices are produced for substantial non-infringing purpose, then the manufacturer cannot be held for copyright infringement. So that also protected the innovation. And then another case is about the peer-to-peer technology. And the first case was the Napster case. And the person on the screen, also on the cover of Times magazine, was named Shine Fanning, who was 18 years old college dropout. And he used the Napster, his own nickname, to form the company called the Napster. And he started the whole peer-to-peer revolution. He designed this the system to allow people to search. He also produced this music share software to allow users to search and make an MP3 music file and from central server and transfer to other computers, so that people can freely share those CDs, the musics. In this case, the court adopted strict rules, and they didn't. They said this is nothing like a Sony case. This is a purely infringement, and also this is not the space shifting and not fair use, and rather it is a contributory infringement, because Napster provided the software and also encourage the user to use their software to download the music, to share the music, and so there's an infringement. So when this case was decided, a lot of people criticized that this will create the obstacle, will damage the internet innovation, but later on, it proven that it didn't really happen. And Napster was later changed to a subscription music platform. So it still exists today, but you need to subscribe and to pay the money to get the music. And another is Google Book project. And in this case, Google scanned 20 million books and making it into digital copies and allowed the user to view in snippet version. And the court eventually held that Google's book project it's not infringement; it's a fair use. And the court provided a lot of the benefit of a Google Book, and they said it's a Google Book. It's very important for the society, for research, for a lot of things. And the court also emphasized the on the importance of for the public, expand the public knowledge and understanding. Also, I would like to see a couple of cases in patent. The one is the Apple versus Samsung, and eventually the court decided there is an infringement by Samsung on 6 patents held by Apple. But interestingly, I noticed that both sides, both Samsung and Apple commented and the case, and by using innovation, both parties emphasize on the innovation of their own company. Like Apple, they said that we value originality and innovation and pour our lives into making the best product on earth. But the Samsung also mentioned the verdict on in favor of Apple. They said they will lead to fewer choices, less innovation, and potentially higher prices. Now here, the two sides emphasize on the innovation from different perspectives. Apple emphasized on the originality, But Samsung, basically, I think they are talking about a different kind of innovation. The innovation based on some original idea and original product, and it's more like a add-on or build follow-up innovation. Another case is software patenting, Alex versus CLS. It's about the computer implemented scheme for mitigating settlement risk. And this risk is that only one party to a financial transaction will pay what it owes. To solve this problem, the company invented this computer implemented the software. And then the court eventually held that this computer program is an abstract idea, therefore it's not patentable. They said that how to solve this risk, prevent the settlement risk, is basically the idea. It's a business idea. You cannot patent this idea. And then another case is about the animal patent. Animal patents involve this so-called Harvard Uncle Mouse. Harvard Uncle Mouse was invented by Philip Leder and Timothy Stewart of Harvard University. So it's called the Harvard Uncle Mouse. Now, basically, the mouse was genetically modified so that they can get the cancer very easily. So that you see all of those mice have the cancer there. So the doctor can, or the researcher can do the experimentation on them. So in the United States, they got the patent for non-human mammals. But for in Europe, they were modified the claim to only cover transgenic rodents. And in Canada, it was rejected because Canada, under Canadian patent law, only higher life form like the mice cannot be patented. Only the lower life form like microorganism can be protected by the patents. And then there's a patent for method of medical treatment that was overturned, invalidated by the Supreme Court, and because this is concerned using identify the effective level of the metabolites, so the doctor can prescribe the dosage of the drugs more precisely. And this was also considered as a abstract idea or law of nature, and therefore it was invalidated for patent protection. And then gene patenting for BRCA1 and BRCA2, I think some of you have heard about this. Angelina Jolie, she tested to have these two genes, so she removed her breast to avoid to get breast cancer. And these two genes, the patent for these two genes were also invalidated by US Supreme Court and under this law of nature or product nature doctrine. And then another case about the diagnostic method, I think it's times. Yeah, this is about a method. This method was actually discovered by one of the Hong Kong CUHK professors. This was a method to find the free, using the free fetal DNA circulating in mother's plasma to diagnose the fetal abnormality. The issue is whether this is a natural law of nature or phenomenon. Unfortunately, this patent was also invalidated by the US court. And also under this law of nature doctrine. And then last case I want to mention is the gene editing patents. You probably, all of us heard that the two researchers, what's the name? Charpentier and Doudna, they got the Nobel Prize for the CRISPR-Cas9, that is a gene editing method. But there's another team that is called the Broad Institute. So the two Nobel Prize winners represent the Berkeley team, and the Professor Zhang Feng represent the Broad Institute, and they actually got patent fight, and both of this team filed a patent for the invention, but the Berkeley team, filed the published paper and also filed the patent earlier than the Broad Institute team. The Broad, however, got the patent earlier because they used the fast track process. So they got the, and also the their patent was more specific about they identified the so-called eukaryotic cell. So this is a more useful cell in this whole method. So they got the patent earlier, and they also, in the patent, in the litigation, the court also decided in favor of the Broad. So you can see that almost all the technology involved the patent, and the filing the patent is so important because that's involved the whole process of innovation, and also the court decision. The court decision more or less have an impact on the development of the technology and also the innovation. And lastly, I would just very quickly go through some of the, the exploitation of IPR. If by owner, then that is more straightforward, and there's a legal. But when there's a multiple owners or inventors, and then that will be more problematic, and sometimes there will be a dispute about who is the true inventor and who is the owners. And when there's co-owners and no agreement to the contrary, then each can use the patent, but they cannot license the patent without consent of other owners. Okay, so and if the IPR or particularly patent is exploited by other people, then that is called technology transfer. Then that's involved the assignment of the patent, and basically that is the transfer of patent ownership and know-how. And then there's also patent license, and also partnership or a joint venture, and the startup and the spin-off. And for assignment, I already mentioned that it's a transfer of ownership. And then the assignor can assign the right of application. So there are two kinds of right. One is a right to apply patent. Another right is a right in the patent. Okay, so when you assign, you need to be aware which right you are assigning. And then it can also, when the company is merged into another company, then your IPR is also normally transferred. And then the assignment should be in writing and also signed. If there's multiple owners, then all the owners should agree to the assignment. Another thing is about the licensing. The licensing is a kind of a permission granted by the patent owner to another to use the patented invention on agreed terms and the condition, while the patent owners continue to retain ownership of the patent. So this licensing have no transfer of ownership. It's only the right to allow other people to use. But licensing is it's very, I think it's highly recommended because it can not only create an income source for the patentee, but also establish a legal framework to the transfer of technology to a wider group of researchers and engineering. So it's not only for one people, you can license to multiple people or companies. So your invention get more people to use. Then it's often used in relation with the competitors in the fragmented market. It's a way to prevent the competition, okay? Because you have a certain control of the competitor. And in this situation, know-how is not shared, okay? Because the ownership is still controlled by the patentee, and so they have a choice not to share the know-how. They only allow the licensee to use the technology. And then there's a very limited collaboration between the party because it's only involved the use of the technology. There's not much research or collaboration involved. And often it's a non-exclusive right are granted. It's recommended to grant non-exclusive license, not exclusive license, unless the other party offers extremely favorable, have a extremely favorable offer. Okay, and there's a voluntary license, and you can basically take many forms like perpetual, one-off, and times constraint, or exclusive or non-exclusive, or oral or written, or express or implied, and those all can be considered as a license. And exclusive license should be very careful because it's more like similar to an assignment. Because once you have this exclusive license, the patentee, the patent owner himself is also excluded from using the technology. Only the patent licensee can use that technology. So you have to be very careful. And after the assignment or license, you have to basically register, particularly for the assignment. For some countries like UK, there's no need to register, but it's highly recommended because there's some consequences. And the US and China all recommend to have to register and also record. Otherwise, your transfer is not valid. Okay, it's voided. And there is also a form of a partnership and startup and spin up. For the companies, usually they will have a partnership with the research institute and to develop some novel medicine. And then usually the know-how is shared, okay, because there's a partnership and collaboration, so know-how is shared. And there's a deep collaboration between the party. And in this case, sometimes the exclusive right, it's granted to the partners. And the different situations require different kind of a form of business. For platform technology or data management, it's better to to found a new company. And for the service in diagnostic or imaging, and then it's recommended for the partnership. And for single-use application, then collaboration is recommended. The key issue in technology transfer include you have to define the scope of technology transfer and identify the IP involved, and also have to define the scope of the right field of use, restriction, and product type. And then you have to decide whether transfer the know-how or whether it will provide any training to the partner or to the transferee. And also reproduction, modification, distribution, whether the license should be exclusive or not exclusive, and whether it should have a geographical restriction, and how about the payment structure. And there's a challenge in the technology transfer involved, how to handle other actors in the market, and how to, because also there's the quality control and how to decide ownership, and there's also the different kind of IP involved, and how to ensure the fair competition. I'm sorry, I think I'm overrun. Yes, I should stop sharing here. Thank you very much, and I welcome any question. I don't know if we still have time to ask questions.
Yeah, a number of questions in the Q&A session. Can you see that? You can pull that up. Yeah. At the bottom. Yeah. And thanks for the sharing. It's very
sorry,
quick.
I forgot my earphone. Hello.
Thank you, Dr. Lee, for your sharing. It's a very great overview, and we have some questions in the Q&A boxes. Can you see that?
Yeah, let me see.
Yeah,
so copyright and patents are never renewable. Yes, unfortunately, yes. Copyright, and it's depending on which country you're in, it's sometimes 50 years plus author's life, and it's expired, and the work will go to the public domain. And patents normally, it's 20 years. Actually, it's 20 years, but in some country they get some extension for pharmaceutical patents, but it's not renewable. Is there any possibility for AI-related software to be patentable? Yes, the AI-related, it depends on whether this AI, whether it's a human being uses the AI as a tool to invent, or whether the invention is totally done by the AI. So there's a AI facilitate invention and the AI generate the invention. So for AI facilitate the invention, it's patentable because it's a human being. But AI generated patent is still arguable. Some people try to file the patent in the name of AI machine. One of the famous cases is Dabus, and the inventor filed the application in the name of Dabus, that is the AI machine, because he said, the whole invention was done by the AI machine. That is the invention for the beverage can and the flashlight. Yeah, so the European Patent Office and the UK Patent Office both rejected the application because they said the AI is not human being. Under the current law, only human being can be inventor. Okay, what is the right time sequence to apply for patent and disclose the invention? The right time, whenever you have the idea, and also reduce the idea to the kind of lab experimentation. Maybe you have some, like some test already have some data, clinical data, then you should start to file the patent. And also you should file the patent in the case when you plan to go to a conference, or when you plan to publish your paper, then you need to file the patent, because once you publish your paper, or once you disclose your invention in the conference, then you will lose the novelty. So it's recommended to file the patent before you decide to disclose your invention.
So Dr. Lee, I just want to have a follow-up questions, like before I publish or put a paper or the data, and or I go to a conference, I should file the patents. So when should I, or when should I like expose or disclose my invention? Like after, because it takes some time to let the patent office to grant you the patent, right?
Yeah, like in there is a U.S. provisional patent, and allow very fast filing. So sometimes the patent can be filed within a few days. So once you filed, then that's basically your invention is protected. So that is one way. Did I answer your question? Maybe I misunderstood your question.
I get it. Yeah.
Okay.
Because I just want the audience also like know more about the provisional patents.
Yeah.
Instead of the formal one.
In some jurisdiction, like in the United States, they have a 1-year grace period. So if you apply for the U.S. patent, and if you publish your paper without filing the patent, then it is possible that you can your invention is still protected by this grace period. Okay. Any famous lawsuit on IP in the APA's regime or in Hong Kong? Mostly I used all of the cases from US and more or less from US and European, because those cases are most famous cases, in IP area, involve the most important technology. So I choose those. In Hong Kong, yes, there's like one case involved the BT peer-to-peer software, and
is it the download BitTorrent?
Yeah, that one is considered as quite popular. A lot of people knows about that case. Yeah, would you recommend startup to go for standard or long-term patent? Yes, it really depends. I think if you are in the business of like a software or like platform, and I don't really recommend to have a very long long-term patent. You can apply for maybe a short-term patent, or it also depends on what product, what invention you have. If your invention involved, like a structure or some minor inventions, like in China, then you can also apply for utility model. That short-term utility models, shorter term, like 10 years or 8 years. And also it's much easier to get granted, and it's also less costly than the long-term patents. Okay. So would I then need to apply trademark in multiple countries when I'm not sure where? Yeah, so this is another very practical issue. it's really depends on how confident you are about your product. If you think your product will be become very popular, and then in many countries there's a demand, then you probably need to apply for the trademark in the country or in the jurisdiction you think you are going to sell your product or use your product. Yeah, so otherwise I don't recommend. Okay. What part of software is patentable, the code or the idea of the, yes, it's a code and the both in source and object code. Talking about the patent, okay, yeah, it should be the code, but to be patentable, it's not only the program per se, it have to have some technical effect, like I think in all the major countries or jurisdictions, like in UK, in EU, in US and China, and I believe in Hong Kong as well. If there's no technical effect or cannot solve any technical problem, the pure computer program cannot be patentable. Okay, and
So,
in fact, in Europe, computer program per se, they said that computer programs per se, that means a pure computer program is not patentable. It's excluded from patentability. Yeah.
So the crucial part is the impact and the effect of that programs, which will bring when we file the patents, but not just the code or.
Yeah, no. Your computer program have to, like using your computer program, the certain product will become more efficient, right? Or they will operate faster, or in a higher quality or something like that. It have to have some practical effect or technical effect in reality,
Okay.
not purely computer program. Okay, it's just computer program. They consider the computer program per se like a mathematical algorithm, which is not patentable. Okay, how long does it take the patent office to consider a patent application in Hong Kong?
How long it takes, yeah, to file a patent in Hong Kong, basically?
Right now, I think because Hong Kong only just started the substantive review examination of patent, the specific time frame I'm not really very clear. That the examination, substantive examinations only started less than 1 year ago, and I think maybe for normally for many jurisdictions it takes 1 year or 1.5 years. For the short term, that is much faster.
The provisional one is much faster.
Maybe just a few months. Yeah.
Do we have provisional patent in Hong Kong?
No, we don't.
I see.
Only US have a provisional patent. I did not get clearly if Professor Chen, medical doctors, medical testing.
I think he is referring one of the example you have mentioned, the medical testing technology.
Oh, that for the fitters?
That one should be from the CUHK professor, right?
CUHK, yeah. It's not protected now. It used to be protected before it had a patent granted, but because someone else used their method and they sued for the infringement, and then the case went to the court, and the court eventually invalidated that patent. So now that testing message is not protected anymore.
Oh, I see. Where was the lawsuit? In the States or in Europe? Just curious.
Yeah, I forgot.
Never mind. Yeah.
Go back. Yeah, go back.
Yeah, we can Google
the
online
PPT.
easily. Yeah.
Yeah. So there's no more question.
Yes.
Yeah,
I think Thank you very much.
Okay. Thank you for giving me
Taurus.
this opportunity. Yeah.
So I guess Dr. Lee has answered all questions.
Yes, I think so.
For next week's event, we will talk about talents you need to build a startup. We got an expert from the Talents Network company. And then for upcoming events, we would like to introduce you the Hong Kong Social Enterprise Challenge. It will be closing applications tomorrow, so do not miss the chance to win 300K cash award in the competition. And then we also have mentorship program organized by MIT Innovation Nooks at Hong Kong. If you want to enhance your prototyping skills, just register by this Friday. Lastly, we will have a free 4 weeks Minecraft virtual events management course. 3 professional tutors will teach you the fundamentals of organizing virtual events and give you guys through the main stage developments in Minecraft. So please feel free to sign up if you are interested. Okay. So thank you very much, Dr. Lee. So this is the end of today's sessions. So see you all next week, and please feel free to continue your discussion via the WhatsApp group. Thank you. Bye-bye.
Okay, bye-bye. Thank you.